First question I'm going to ask, how did the prosecution explain that there were no wounds on Avery, but his blood was found in the car?
That one's probably directed at me. If you watch very closely, and there are people out there watching very closely because people have spotted things that I had never had spotted, but if you watch very closely, by the time TV crews are filming Stephen Avery at the salvage yard a few days after Teresa Halbach has disappeared, there's a cut on his right finger, on his right index finger. It's clearly not a very old cut, but it's not clear just how old the cut was. And he's a guy who works in the salvage yard, so, you know, his hands are all chewed up and scarred. And, you know, the prosecution never made a lot of that cut, in part because the police asked Stephen about the cut, and he readily explained when he got it, and it was after she would have disappeared. It was after Halloween. And to look at the cut, you know, that explanation was plausible. Not certain, but plausible. So the prosecution argued an inference that he may well have had that cut earlier than he said he got it. And that was that's the short answer to your question. That was the argument. It was just an inference. I mean, it was the argument you and I would have made had we been prosecuting the case, that he probably lied about when he got the cut. He probably had it a few days earlier. But, you know, that was something that did conflict with a ready answer that he gave when asked about it. And the age of the cut, you couldn't put it to a given day.
Lou, let me bring this over to you and your experience in Los Angeles criminal law. Would you think that a DA in the Los Angeles arena would really harp on something like that?
Yeah, I thought that would be a pretty big deal to both sides, and I would have expected maybe medical experts to get involved to try to testify as to how old that wound was, how long it had been there. Did that happen in the case?
No.
And why do you think that didn't happen?
I don't know.
Well, it sounds like you had the better argument as it stood, so you didn't want a wound expert coming in there.
Well,
right?
and again, we got involved 2.5 months later. I mean,
the wound was gone.
Long gone.
Right.
By then. It was a fairly superficial cut. He wasn't even wearing a bandage on it when it was filmed on TV.
Was there so much blood in the car that it would be consistent with the small wound? Was that? And Anahita, do you want to jump in on that?
Yeah, now I was going to actually talk about the blood now that we're talking about the wound. So a lot was made of Stephen Avery's blood in this documentary. And one of the things that was brought up is that his blood was found in Teresa Halbach's car. And the defense did, I think, a great job in poking holes in the testimony of the expert in terms of how this blood was tested. Was all the blood tested? There was some testimony about there not being any EDTA in the blood. So my understanding now is that Stephen Avery's new attorney is trying to come up or find somebody to come up with a new test to retest that blood to see if there's a more accurate test to determine if there was any EDTA. So if you can explain what EDTA is and what you made of that blood evidence.
Well, EDTA, actually, there was a time familiar to all of you when people were talking about EDTA, and that's when Orenthal James Simpson was charged with a double murder in Brentwood. Because that's the last time the FBI did EDTA testing, was actually in the People v. Simpson. And then the FBI decided that the science wasn't so good and that the testing often wasn't all that helpful, and got out of the business. But what EDTA is, it's a common chemical that's consumable even. I mean, it can be put in food, but it's in a number of household products, and it's designed to keep things in a liquid state. So it's useful in blood vial as, in effect, an anticoagulant to keep blood in a liquid state. And the relevance here, or the sort of much of the fighting issue here, which doesn't come out completely in the film, is that the FBI didn't know the detection limits for the test it was running. So in other words, it didn't know the floor at which the test wouldn't detect EDTA that was there. Didn't know what that was. Didn't have a validated protocol overall, but you know, the real concern was one, the lack of known detection limits, and then two, I think more importantly, no idea about the differing rates of degradation or loss, elimination of EDTA in different environments. So in other words, in a sealed vial or nearly sealed vial, might the EDTA persist longer than in an ambient environment where there's sunlight, heat, cold, and, you know, potentially other chemicals on a surface. That was unknown and couldn't be, you know, so therefore couldn't be offered by the FBI analyst at trial.
And obviously, the defense's position on that was that the blood was actually planted by the investigators, by the police, from the vial of Stephen Avery's blood that they had in police custody, correct, from his prior case?
I don't mean to split hairs, but we did try to be pretty careful on that one, that it could have been.
Could have been.
His blood was available in the courthouse. The courthouse was under the custody of the sheriff's department. The seal to the box had been broken without explanation.
We'll get to
Whoa,
the
whoa, whoa.
blood vial. We have a series of
right,
questions
because
on
there's
that
a
one.
follow-up on that. I have so many questions.
I think our expert has something he wants to add.
You know, I confess, I'm one of those binge viewers back in December, and I found it to be very compelling. And this is before Lou contacted me, and asked me to participate in this panel. And I was very interested and very entertained by it, and very concerned about it, because my thing is, and was when I was a police officer, conducting interviews and interrogations that have some credibility to them. And I was concerned about credibility issues. And then Lou contacted me. And instead of binge watching, I watched it more closely and I did some research. And I learned that even though we were only shown about 8 minutes of the interrogation of Brendan, that in fact the interrogation itself took over 4 hours. And there were 2 or 3 interviews that went on for hours before that. And speaking about the blood question, Brendan states within that interrogation that when he first went to the trailer, he saw blood on Mr. Avery's hand. Now, I don't know where that injury was. Was that on his right hand?
On the right hand, yes.
Because that was where Brendan was pointing. And at the time that he arrived there, I don't recall him having said anything about injuries being seen on the victim, just on Mr. Avery. Now, I'm an ex-cop. And now I work for the dark side. And I try to explain to my former coworkers that what I'm doing now really isn't that different from what I did before. I search for the truth. The one difference is if I find the truth and it doesn't quite jibe with the defense attorneys I'm working with, and there's this thing called attorney-client privilege that kicks in. And we can't bring that truth out. But I'm really concerned when we talk about a rush to judgment and we see a very, as I said, compelling documentary series, 10 hours. But it's my understanding there was approximately 600 hours of trial that took place. And how many hours of actual testimony, examination, cross-examination did we witness? Oh, I'm sorry, it wasn't hours, was it? It was minutes. It was less than an hour. And while I did find it very compelling, the series, and it certainly brought up a lot of valid issues that I think we ought to discuss, including what is or is not the proper means to conduct an interview or interrogation. I got to ask you, is this what we want for justice? A documentary where the majority of the things that we see are things that would never be admissible as evidence. Brendan talking with his mom about how tough his situation is. Mr. Avery talking with his girlfriends, talking with his attorneys, the attorneys conferring. Mr. Strang saying how tough a situation this is, that an innocent person would be charged with this crime. Now, I'm not a lawyer. I've worked with a lot of them, but I'm not a lawyer. And it's my understanding that these things are not evidence. And I'm not going to second guess the jury that's had the ability to review all of that evidence based on less than an hour of testimony. I just can't do it.
Let me step in here. Just for the time's sake, I'm going to rapid fire you guys some questions. And Anahita, I'm going to jump to the blood vial in just a moment. But let me stay with you. And for a moment, if you could tell people what your expertise is.
I was in law enforcement for 32 years. I retired as a sergeant from the City of Santa Monica Police Department. And almost from the time I started, I developed an interest in getting factual information from people that I was dealing with on the street. Interviews and interrogations. In 1991, I attended a class entitled Homicide for Patrol Officers, and that included an 8-hour overview of behavioral analysis-based interview and interrogation that was presented by John Reed and Associates. And I thought it was a very, very interesting way to do my job better in order to identify who was the actual offender and who might be an innocent person. And I got into it. I got into it real quick. In fact, after going to this 8-hour class, I ordered their book. The book arrived within a week. I was working night shift at the time. I started reading at about noon. When I received the book, I had to go into work at 4. And that evening at 7 o'clock, I was involved in the arrest of 3 young men who had a pellet gun. And the call came in that it was just 3 kids with what appeared to be a handgun. We detained them. They provided some information. We were just kind of hanging out. We weren't going to do anything. And one of the neighbors said that a friend of his, 3 blocks away, a couple weeks earlier, had been robbed at gunpoint, and that the gun used was a .45 automatic. And the pellet gun looked like a .45. And based on that information and their similarity to the suspect description, I arrested them. And because I was very lucky, if they were adults, I wouldn't have been able to interrogate them. Our policy is that if you have a juvenile, though, the patrol officers can do an interrogation. I did an interrogation of all 3, and one of those subjects, using the techniques that I was given, one of those suspects told me he did it. He did the robbery, and he described the robbery, and he described where the victim's property was. And he described who the other 2 offenders were, and it wasn't the 2 people that had been arrested with him earlier. So I found the right person, I identified the other suspects, and I exonerated the 2 that were with him based upon, 8 hours of classroom and about 3 hours of reading.
But just so I can, to the very original question, coercion expert, you study coercion, you study how investigations go when it's a one-on-one, they have people in the room and the police officer asking them questions, correct?
I study how you get credible information from someone that is against their penal interest.
And then let me
Is
a-
it coercive? Is it not coercive? Look, the Supreme Court ruled in Miranda that just being in an arrest situation is a coercive environment. The question is, are the tactics used excessively coercive? Are
Let
the
me,
tactics
just because
used-
the time is low and I
Sorry.
want to come back to the blood vial, but let me continue with you with one last follow-up question, real quick, and I'm going to put you on the spot here, sir. You've watched the documentary, you watched the interrogation process, real quick. You're not one side or the other, veil of ignorance, absolute objectivity. From what you saw, at least in the documentary, what did you think of the interrogation process?
I saw problems. I was very concerned when I saw the short clip of Brendan being interviewed that was broadcast. But when I had an opportunity to see the 4 hours, which, by the way, if you're interested, I can make that available as a link through your YouTube site, that there were some things that Brendan said, which I learned later were corroborated, and they weren't leading questions. And the way he said these things indicated that he knew what he was talking about. I don't want to take up too much time. We can go into that later, but there's a lot more to it than the 8 minutes that we
Can
saw
I
in
just
the video.
make a quick comment just
Please.
in response to that? I think a lot of us that have watched this documentary understand that it is a film. There has to be some entertainment value in it. Not all 200 hours of the trial will be put in this 10-hour documentary, but I think what troubles a lot of us is the fact that we didn't have to necessarily see the entire 4-hour interrogation to see that this was a 16-year-old boy. He was clearly cognitively impaired. He had an IQ of 70. And when you look at some of those tactics that were used, I don't care if the rest of the 3 hours of those interrogations were proper. That was clearly, by any standard, an improper interrogation. The kid needed to be evaluated, and that's something I think we need to talk about because that was never brought up in the documentary. At what point in time do detectives or officers have an obligation to say, perhaps this child or this individual is not understanding what we're asking him? Perhaps he's not competent to sit for an interrogation, and I think that's part of the thing that's troubling for many of us. And that has nothing to do with guilt or innocence. It just has to do with the criminal justice system, and did it fail this child? And I think a lot of us believe it did on every level.
Well,
Okay. Let me kick in here. Dean, I know this is not one of the pre-listed questions, and I apologize for going slightly off the script, but looking at everyone here, this interrogation portion is obviously a hot topic.
This can be unscripted. It's okay.
Okay.
Life is.
You know, I'm not a criminal defense attorney. I'm not. But I watched that, and I couldn't make heads or tails. I'm so lost. From your position as an attorney, as someone who provides a civil service, what did you think of that?
Are you asking me?
No, I'm asking Dean.
Oh, Dean, okay. I'm like, I thought I expressed my opinion pretty clearly.
What did I think about the Dassey interview by the police?
Yes.
I thought it was troubling, and I watched all 3.5+ hours, almost 4 hours of it too. I just thought it was troubling. There's an awful lot that's suggested to him, and there are certainly things that aren't suggested to him. So I don't want to suggest that any of this is clear. These are very murky cases. In the end, they're very murky cases. But I was troubled by his obvious developmental delays and just, lack, I guess, of worldliness. Worse in that respect, or younger in that respect than his chronological age. I'm an easy touch, I guess. I'm a defense-oriented person, but having seen all of it, the whole of it left me really unsettled.
And let me open this up to the panel real quick, just because we want to get that break in there shortly. But what are some coercive techniques you guys have seen in your pendency as professionals? What are things you've seen that judges have even ruled on as coercive?
well, I'll tell you how I got in this in the first place. You want to talk about coercive. When I retired and I got my PI license, I applied for and was placed on the panel, the Superior Court panel for indigent defendants, criminal defendants in the LA County Superior Court. And one of the cases that I was appointed to was a gang shooting case where a vehicle was involved that was associated with someone that the police believed could have been the shooter because that person, even though he had no record whatsoever, had been seen at a house that was frequented by known gang members. Now, the fact that this guy happened to live next door to that house, and he'd grown up there, and he knew these other kids all his life, didn't seem to factor into the police decision that this was the guy that did it. So, this kid that was developmentally disabled was at home one day, and there's a knock at the door, and it's a hardcore member of the street gang that he was associated with that he didn't know. Somebody that the police had gotten out of jail. He was in on a serious charge, wired him up, and told him, we want to find out if this guy is the one that did the shooting. Acting as the agent for the police, this veterano told the guy, you don't know me, but you can call your friends over there. They'll tell you who I am. I'm Sniper or whatever. And I have a meeting with MA in a couple, 3 days. I don't want any details from you, but you know that it's forbidden to do drive-by shootings. And the other gang that lost their buddy the other day is saying, you did this and you did it as a drive-by. And if you don't tell me you did it, and I don't want any details, you don't have to provide any details, I just want you to say you did it. If you don't tell me you did it, you're going to be green-lighted. Now, does everybody here know what green-lighted means? Well, he knew what it meant. And he said, I don't know what you're talking about. And 45 minutes of coercion from this guy saying, you're going to be killed, your family's going to be killed, your friends are going to be killed, there's going to be shankings in the jail. All you have to do is say you did it, and you did it as a walk-up. Oh, and by the way, why are you looking so scared? I'm the one that should be nervous. I'm on parole. I got a gun in the car right now. 45 minutes of this, and the kid finally says, okay, I did it. And the DA's office filed on that after the investigator said this was an approved way to get statements from a gang suspect. Now, I know there's a lot of things that are said about John Reed and Associates that, well, one of the things they teach is in interrogation is you don't call people a liar, you just say they're not telling you the truth. That all they want is a confession, and they're not looking for the truth. Well, I talked to Joe Buckley, who runs John Reed and Associates, and Joe told me when I asked him if he'd ever heard of a technique like this being used or approved, and he unequivocally said no. And I testified on that case, 3 different trials, one of which ended up hung 11-1 for not guilty before the case was ultimately dismissed. Now, I don't know if the kid did it or not. I can't tell you. But I can tell you that that's as good of an example of a coerced confession that I've ever seen, and it has absolutely nothing to do with formal training. Absolutely nothing.
You can stay now, Gary.
Thank you.
I was a little on the fence there before. But. The Reed method, by the way, is in your handout. It's the method that's been used by law enforcement for over 50 years, and it's part of the MCLE handout if you want to know more how it's executed and so forth.
Okay. Let's do this, guys. It's about 8:10. Why don't we take the break for the evening?